Probate takes how long? Families are not ready for this. When you're grieving, the last thing you want is a legal process that feels impossible. You just want to know, how long does probate really take in California? You might hear about a year, but that doesn't explain the built-in waiting periods that make it feel so slow. It's a daunting and stressful process. Today we're going to give you a clear and simple roadmap. We will break down the official journey step by step so that you know exactly what to expect. If you're feeling overwhelmed with organizing personal assets, handling a property cleanout, keeping up with maintenance, or need trusted referrals for a certified public accountant or a state attorney, I'm here to help. Drop your questions in the comments or reach out directly. I'll be able to guide you through. Deciding whether to keep, lease, or sell a family home can be emotionally draining and work intensive. A full-service approach takes care of everything from property cleanout and repairs to staging, marketing, and selling, so you don't have to manage it alone. We want to replace your anxiety with clarity and give you a realistic map of what is ahead. Understanding the process is the first step to feeling in control. So let's get right to it. How long does a typical probate case in California take? The honest answer is anywhere from 12 to 18 months. We know that sounds like an impossibly long time to settle a loved one's affairs. The main reason is that the law has mandatory waiting periods. These are not suggestions, they are legal requirements. The system is deliberately slow. This is to give everyone involved a fair chance to be notified. This includes heirs, beneficiaries, and especially creditors. So even if the state is perfectly organized, there is a valid will and all the heirs get along, you legally cannot rush certain parts. The biggest mandatory hurdle is the 4-month waiting period just for creditors. That alone sets a timeline that's nearly half a year. California law says probate should be done within a year, but extensions are common. This makes the 12 to 18 month time frame the reality for most families. Think of it not as a single race, but as a series of steps. Let's walk through them together. Step 1, filing the petition and getting a hearing date. The first 30 to 60 days. So how and where do you get started? The whole process begins when someone, often the person named as executor, files a petition for probate. It's the official start. It is filed in the Superior Court of the county where your loved one lived. For example, here in Orange County, this petition tells the court about the death. It presents the will to be validated, and it asks the judge to appoint someone to be in charge. This person is the personal representative. The personal representative, also called an executor or administrator. Once it's filed, the court gives you a case number and a hearing date. This first court hearing is usually scheduled 30 to 45 days later. So right away, you have a 1 to 2 month wait just to get in front of the judge. During this time, you are required to give notice to everyone who might have an interest in the estate. This includes all heirs and beneficiaries. You also have to publish a notice in a local newspaper. This is a public announcement that probate has begun. It serves as a heads up to any unknown creditors. Step 2, the first court hearing and the mandatory creditor. Clock 4 months. When the hearing date arrives, the judge will review your paperwork. If everything is in order, the judge will sign an order appointing you as the personal representative. This allows the court to issue a vital document called letters. These letters are your legal authority. They are the official court document that gives you the power to act for the estate. With these, you can now access bank accounts, talk to financial institutions, and manage the estate's business. The moment these letters are issued, a much longer clock starts ticking. The creditor claim period. From this date, creditors have a mandatory 4-month window to file a formal claim for any debts. This is the single biggest unavoidable delay in the probate process. Even if there are no debts, the law demands you wait for this period to end. You cannot skip it, and you cannot shorten it. Step 3, inventory and appraisal. 2 to 6 months. While that 4-month creditor clock is ticking, your work as the representative is in full swing. One of your biggest jobs is to complete the inventory and appraisal. This is a detailed list of everything the person owned. It also lists what each item was worth on the date of death. You have 4 months from your appointment to file this with the court. Assets are split into 2 groups. The first is cash and bank accounts, which you can appraise yourself. The second group is everything else: real estate, cars, stocks, or business interests. These things must be valued by a neutral expert called a probate referee. This part can be quick if the estate is simple, but it's also where delays can happen. Appraising a unique business or the family home can take time. Getting this valuation right is critical. It impacts how assets are divided among the siblings and what taxes are owed. This step is key to preserving family peace. Step 4, managing the estate, paying debts and taxes. This is ongoing. Throughout this whole time, you are actively managing the estate. This means paying final bills and handling ongoing expenses like a mortgage. It also means dealing with any creditor claims that were filed. If a creditor files a claim, you must review it. If it's valid, you pay it from the estate. If not, you can formally reject it. A rejection could lead to a lawsuit and more delays. This is also tax time. You have to file final personal income tax returns. There might also be tax returns for any income the estate earns. Missing these deadlines can lead to penalties and interest, so it's vital to stay organized. You cannot give a single dollar to a beneficiary until you can prove to the court that all legitimate debts and taxes are paid, or will be. Step 5, petition for final distribution and the second court hearing. It adds 2 to 4 months. Once the 4-month creditor period is over, the inventory is done, all debts are paid, and all taxes are filed, you are finally on the home stretch. Now you file the petition for final distribution. This is your final report card to the court. It is a detailed document showing everything you did, list what you collected, what bills you paid, and a plan to distribute what's left to the beneficiaries. Just like at the beginning, the court sets another hearing date, usually 30 to 60 days out. At this final hearing, if the judge agrees you have done everything correctly, they will sign an order. That order is the green light you've been working toward. Step 6, closing the estate, the final lap. With the judge's signed order, you can finally distribute the assets. You will write checks and transfer property titles. Once everything is in the hands of the rightful heirs and you have receipts, you file one last form. This form tells the court your duties are done. The court then formally discharges you and the probate case is officially closed. That 12 to 18-month timeline assumes a smooth ride. Sadly, things can go wrong that stretch the process to 2 years or even longer. The most common delay is conflict. If an heir contests the will, everything can grind to a halt. Will contests can add years of litigation and significant cost. Selling the inherited property can also be a major wild card. If the Orange County market is slow or the home needs repairs, it can take longer than expected to get it sold. Other delays include dealing with complex assets like family businesses or simply getting stuck in a backed up court system. So there you have it. The California probate timeline is long because it's designed to be methodical and fair. Understanding these steps is the most powerful tool you'll have. It lets you set realistic expectations for your family and navigates this journey with a clear map. If you are the personal representative for your family estate and feel overwhelmed, you do not have to do it alone. This is what we do. Our team is here to guide you through every step. There's a link in the description where you can book a consultation. We can help you build a clear strategy and lift the weight of this process from your shoulders. Thanks for watching. We hope this brought you some much needed clarity. If this video helped you, here's the next one right over here that you will want to watch.